This is Daury versus Smith. It was heard in the First Circuit Court of Appeals in 1988. Jeffrey Daury was a former principal and a current grade leader in the Pittsburgh, Massachusetts school system. He started as a principal in 1970. 9 years later, his evaluation results began to decline. He worked as a member of the negotiating team for the Teachers Association from 1979 to 1983. At the end of the school year in 1983, the district determined to close the school, meaning a principal position would be eliminated. Daury was demoted to the position of grade leader. Daury filed a grievance, but the committee determined that the district had acted in accordance with collective bargaining agreements, which considered both seniority and performance. 3 specific incidents led to the district's decision to require Daury to see a psychiatrist prior to a return to work. First, in a meeting about district funding, Daury brought up a personal matter that led to an argument. This argument nearly became physically violent and led to Daury receiving a reprimand from the superintendent. Second, a month later, Daury found that there were unsigned documents in his personnel file, contrary to the collective bargaining agreement. Later that day, he had an argument regarding the unsigned documents with another administrator in the parking lot. He was suspended for 3 days without pay. Daury filed a grievance. The suspension was cut down to 1 day, and the documents were removed from his file. Finally, 7 months later, he was supervising students crossing the street when a student started to cross unsafely. Daury told the boy to stop, and the boy swore at him. Daury said he grabbed the boy's arm. Witnesses said Daury put the boy in a stranglehold. The police intervened, and the boy was released. Before the criminal trial, Daury met with a representative of the Teachers Association, assistant superintendent, and superintendent. During the meeting, Daury stated he was under a lot of pressure and he thought he needed some tranquilizers. Daury was put on a leave of absence with pay until the end of the school year, which was less than a month away. The school committee approved this and added that Daury would be required to see a psychiatrist before a return to work. Daury sued, saying that requiring him to see a psychiatrist violated his privacy and liberty under the 9th and 14th Amendments because it forced him to reveal information about personal matters such as relationships and family as a condition of his employment. The court determined that, in alignment with the Lyons case, there was reasonable basis for questioning Daury's mental condition, as his condition might jeopardize the welfare of students. This reasonable basis includes the incident with grabbing the boy, due to the severity which was illustrated by the criminal suit, Daury's own comments of needing tranquilizers, 2 near physical confrontations, and other complaints from parents.